Hi guys, welcome to our channel. I started making a series of videos on Indian Penal Code 1860 recently and I have uploaded a few videos. So I hope that you saw those videos, and if not, then please check them out. I request you to watch all the videos from our channel and also press the bell icon next to subscribe button to get all the updates on our upcoming videos. Also subscribe to our channel. Today this video is on chapter 5 of IPC, which covers section 107 to 120. Section 107 to 120 of this code is on topic of offences relating to abatement as provided in this chapter in IPC. I hope this video will be helpful to you. In this video I am going to discuss section 107 and the remaining provisions from this chapter will be discussed in the upcoming videos. This video is part 1. Section 107, Abatement of a thing. A person abets the doing of a thing who first instigates any person to do that thing, or secondly engages with one or more other person or persons in any conspiracy for the doing of that thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or thirdly intentionally aids by any act or illegal omission the doing of that thing. Explanation 1. A person who by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose voluntarily causes to procure or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. Illustration. A public officer is authorized by a warrant from a court of justice to apprehend Z. B, knowing that fact and also that C is not Z, willfully represents A that C is Z and thereby intentionally causes A to apprehend C. Hereby B abets the instigation of C. Explanation 2. Whoever either prior to or at the time of the commission of an act does anything in order to facilitate commission of that act and thereby facilitate the commission thereof is said to aid the doing of the act. Explanation. According to section 107, abatement of a thing can be by instigation, by conspiracy or by intentional aiding. It is clear from the definition that abatement involves active complicity on the part of the abetter at a point of time prior to the actual commission or doing of that thing. The definition given under IPC has found reference in General Clauses Act 1897, subsection 1 of which says that in this act and in all central acts and regulations made after the commencement of this act, unless there is anything repugnant in the subject or context, abet with its grammatical variations and cognate expressions shall have the same meaning as in the Indian Penal Code. Section 4 subsection 2 of the act says that the definition of abet in section 3 subsection 1 apply also unless there is anything repugnant in the subject or context to all central acts and regulations made on or after the 14th day of January 1887. Abatement by instigation. According to the first clause of section 107 of the code, a person abets the doing of a thing who instigates any person to do that thing. What is instigation has, however, not been defined by the code, but the first explanation under this section, which should be read with the first clause, states that person who by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. The illustration attached to the explanation also makes the explanation amply clear. A person is said to instigate another when he incites, urges, encourages, goads, solicits, provokes, counsels, procures, or commands him to do something. Mere advice generally is not instigation, but it may be so where the intention is to actively suggest or stimulate the doing of something. Where the husband and the mother-in-law of the deceased by direct and indirect words and conduct treated her cruelly and actively suggested suicide, as a result of which she committed suicide. They were held guilty of abatement by instigation to commit suicide. The relations between a married couple were strained and the husband was residing away from the marital home. The wife believed that husband's employer was to be blamed for this. She tried to persuade her husband to return home and threatened that if he would not do so, she would burn herself to death. The husband did not respond and asked her to do her best. When she lighted the match on herself in front of her husband and his employer, neither tried to stop her, as the result of which she died of burns. It was held that the two could not be held liable for abatement by instigation to commit suicide, as there was no instigation on their part and there was no law under which they were obliged to put off the fire. The court remarked that the law could not be different, otherwise innocent persons would have to be held liable if they failed to comply with unreasonable demands of others. Where an officer handed over the keys of a cash box to his subordinate clerk, who opened the same and in his absence and absconded with the money, it was held that only this much of evidence was not enough to hold the officer guilty of abatement by instigation. Conspiracy of aiding, as his act at most would be said to be negligence or failure in the observance of the office rules. The Supreme Court has held that it cannot be the law that a person can never be convicted of abetting an offence when the person alleged to have committed that offence in pursuance of that abatement has been acquitted. It is only in case of abatement by intentional aiding that conviction for abatement cannot be maintained when the person alleged to have committed the offence is acquitted of that offence. The giver of a bribe to a public servant is an abettor of the offence of accepting illegal gratification by public servant, whether the bribe is given voluntarily or in response to a demand made. Where instigation to commit an offence has been given by a letter, the offence of abatement is complete only when the contents of the letter come to the knowledge of the person who is being instigated. Similar rule will apply for instigation through telephone. If the letter or the communication never reaches, it will be a case of attempt of abatement by instigation. The deceased had ended her life by self-immolation about 2 years after her marriage, when none of the members of the family of her in-laws was present in the house. It was not proved by evidence that it was a case of humiliation and harassment of the woman on account of non-fulfillment of additional demand of dowry. While holding the mother-in-law of the deceased not guilty of abatement or suicide, the Madhya Pradesh High Court observed that the extreme step was taken probably out of frustration and pessimism due to the sensitiveness and sentimentalism of the deceased. On the other hand, where the husband used to demand money from his wife almost every day, when they used to quarrel also, and on the fateful day, the wife reacted by saying that she would prefer death to life in this word, to which the husband retorted that he would provide him quicker relief if she died the very same day, immediately after which she set herself on the fire and died. The Supreme Court held that husband guilty of abatement by instigation to commit suicide. In another case, a newly wedded girl died of burns. The evidence of her father and sister indicated that the deceased had complained about harassment and torture by her in-laws for bringing insufficient dowry. The in-laws, on the other hand, had been accusing her of carrying an illegitimate child. The father of the deceased had stated in the FIR itself that the deceased committed suicide because of harassment and constant taunts and torture. There was a delay in giving medical assistance to the deceased, and the information of the incident was also not promptly communicated to her father. No burn injuries were found on the fingertips of any member of the family of the accused. It was held by the Supreme Court that the deceased had committed suicide at the instigation of her husband and in-laws, and it was not a case of accidental death. In Syriac versus Sub-Inspector of Police Kaduthururthi, the Kerala High Court observed that a person who instigates another has to provoke, incite, urge or encourage doing of an act by the other by goading or urging forward. The deceased owed 200 to the accused. The accused persons cannot be said to have abetted deceased to commit suicide by merely telling him in public, "Why are you remaining as a burden to earth? Why can't you go and die?" etc. This is insulting and abusive, but not abatement by instigation to commit suicide. Abatement by conspiracy. The second clause of this section states that a person abets the doing of a thing who engages with one or more other person or persons in any conspiracy for the doing of that thing, if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing. The language is clear to the effect that the basis of abatement by conspiracy is engagement between the abettor and the other person or persons in conspiracy for the doing of that thing, and not agreement as stated in section 120A for criminal conspiracy. Agreement means putting an intention into effect, and naturally therefore full details of every bit of an act is known to all the conspirators. Such is not the case in engagement, which means that even though all the smallest details of the act are not known, yet one is associated by and large actively in the plan at some stage. Explanation 5 to section 108 of the code and the illustration appended therein help one to understand as to what really is meant by engagement. The explanation says that it is not necessary to the commission of the offence of abatement by conspiracy that the abettor should concert the offence with the person who commits it. It is sufficient if he engages in the conspiracy in pursuance of which the offence is committed. The illustration is A concerts with B planning for poisoning Z. It is agreed that A shall administer the poison. B then explains the plan to C, mentioning that a third person is to administer the poison, but without mentioning A's name. C agrees to procure the poison and procures and delivers it to B for the purpose of its being used in the manner explained. A administers the poison. Z dies in consequence. Here, though A and C have not conspired together, yet C has been engaged in the conspiracy in pursuance of which Z has been murdered. C has therefore committed the offence defined in this section and is liable to the punishment. In this illustration, it is worth noting that C does not know who is to administer the poison and when it will be administered, but he does know that the poison would be used for an unlawful purpose, and even then he allows himself to be part of it. This is how he engages in the conspiracy and is therefore guilty of abatement by conspiracy. The distinction between the crimes of abatement by conspiracy and criminal conspiracy has been dealt with under section 120A of the code. In Roop Devi vs. State, the deceased and his wife had strained relationship. The wife had illicit intimacy with the accused. The deceased was scheduled to go to a sadhu on a particular day. The wife told the accused about his program of her husband, even though she knew that the accused was wanting for an opportunity to kill him. The accused ambushed and killed him. It was held that on the basis of this much evidence, the wife could not be held guilty of abatement by conspiracy, even though her conduct was open to censure. The decision has been criticized on the ground that the complicity between the woman and the accused is easily deducible for the facts of the case. It, however, seems that the court hesitated to draw the conclusion of an engagement between the two, which is necessary to convict the woman of abatement by conspiracy, and also that the evidence as it existed was not enough to show that the act had taken place in pursuance of that conspiracy, where certain persons prepared a copy of an intended false document, brought paper with a view to prepare such a document, and asked for certain information regarding the fact which they had an intention to insert in that false document. It was held that all these evidence showed that they were acting under an engagement to commit forgery, because these acts were done to facilitate the commission of that offence. Abatement by aiding. The third clause of this section states that a person abets the doing of a thing who intentionally aids by an act or illegal omission the doing of that thing. The clause should be read with the second explanation, according to which, however, whoever either prior to or at the time of the commission of the act does anything in order to facilitate the commission of that act and thereby facilitates the commission thereof, is said to aid in the doing of the act. Mere aiding is not enough under this clause. The same must be intentional. The abettor must aid intentionally by any act or illegal omission the doing of that thing. An illegal omission takes place where there is a legal duty to act, but the person fails to act. The explanation clarifies that aiding is possible only either prior to or at the time of the commission of an act and not after an act has already been done or committed. It also explains that in abatement, by aiding something must be done in order to facilitate the commission of an act, and also that such doing must facilitate the commission thereof. This therefore means that mere intention to facilitate coupled with an act calculated to facilitate is not sufficient to constitute abatement by aiding unless the act which is intended to facilitate in fact takes place and is facilitated thereby. Here is an illustration that if a servant keeps open gates of his master's house so that thieves may enter, and thieves do not come, he cannot be held to have abetted the commission of theft. Where the accused person tried their utmost to dissuade a woman from committing suicide by becoming sati and even informed the police about it, but ultimately finding it impossible to dissuade her, complied with her and helped her in the process, it was held that they were liable for abatement by intentional aiding of suicide. Where the accused allowed an illegal marriage to take place at the house of the accused, no liability for abatement by aiding exists because the facility given must be such as is essential for the commission of the offence in question. On similar grounds, giving consent to be present in an illegal marriage or being actually present in it or giving facility by grant of accommodation for such a marriage to take place will not make one liable for abatement by aiding, but a priest who solemnized an illegal marriage intentionally and thereby facilitate such marriage to take place was held liable for abatement by aiding. Where a person supplies food to a person whom he knows to be engaged in committing crime, that by itself does not make him liable for abatement by conspiracy, but if the food has given the food has been given in order to make him undertake a journey to the place where the crime is scheduled to be committed, or to enable him to conceal himself at a convenient place while waiting for the appropriate moment to commit the crime, the act of giving food may not amount to facilitating the commission of crime which does facilitate it. Where the accused entered into a parlour without having knowledge as to what kind of a film was going to be exhibited there, he could not be held liable for abatement by aiding obscenity even if blue film was being exhibited there. Where a head constable intentionally went away from the place knowing fully well that third degree methods would be used against a person there with a view to extort confession from him, it was held that he was guilty of abatement by aiding. Where a married pregnant woman had not eaten anything for 3 or 4 days before committing suicide, and the atmosphere in their home before the suicide was very tense and her husband and in-laws did not persuade her to eat, it was held that husband and in-laws could not be said to have abetted her by aiding to commit suicide, and it seemed to be case of sensitive woman not being able to put up with the normal pressures of life. In Dayaram Fukan versus State, a person was charged of having accepted bribe of ₹100 from another and the accused with abatement by aiding of this offence. The charge of bribery could not be proved and the person was acquitted of the charge. The Assam High Court held that the acquittal of the alleged principal offender, the accused could not be held liable for committing the offence of abetting by aiding. The decision of Supreme Court in Faguna Kanta Nath versus State was thus relied on this case. In Sundar versus State of UP, the Allahabad High Court held that a person cannot ever be convicted of abetting a certain offence when the person alleged to have committed the same has been acquitted. In Trilochan Singh versus Karnail Singh, the respondent was charged inter alia with having entered into an agreement with 2 influential leaders of the Harijans that if the Harijans voted for him,
he would donate a sum of rupees 1500 towards construction of a dharamshala for them. The amount was paid on the understanding in presence of the accused, who was charged with the offence of abatement. The Punjab High Court held that the failure on the part of the accused to inform the authorities about the transaction did not make him liable for abatement by aiding, as there was no legal obligation on him to inform the authorities about it, and not informing them therefore did not amount to illegal omission. The decision would remain the same even if the accused had intentionally done so, because even then it would not be an illegal omission on his part. In Tej Singh versus State, a widow was walking along with other persons at a funeral procession of her husband with the intention of committing sati. The processionists were chanting Sati Mata Ki Jai. About 15 or 100 processionists surrounded the police with a view to prevent it from acting. The funeral pyre was lit with the widow sitting on it. 12 accused persons had been identified who had taken active part right from the stage when the widow's husband had died. The Rajasthan High Court convicted all the 12 persons, holding that all of them had intentionally aided the widow to commit sati. A police officer is under a legal duty to provide shelter to a person who is under the custody, and to arrest such persons who are committing assault on such persons with the intention of causing grievous hurt to him. And if he fails in his duty, it is an illegal commission on his part. If such failure is intentional, he is guilty of abatement by intentional aiding. Where the accused sought the aid of a servant to commit the theft in the servant's master's house, and the servant, with the consent of his master and for procuring the arrest of the accused, aided him in carrying out his intention, it was held that though theft could not be committed, yet the accused was guilty of abatement of theft. In Ram Kumar versus State of Himachal Pradesh, the 19-year-old prosecutrix was taken to the police station by the accused, who kept a watch over her husband while she was being raped by a co-accused. In this custodial rape, the accused turned deaf ears towards the cries of the prosecutrix and did nothing to help her. The Supreme Court upheld the conviction of the accused for abatement of rape. In Central Bureau of Investigation versus VC Shukla, the Supreme Court held that where no prima facie case was made out against one of the accused of having committed an offence under Section 7 of the Prevention of Corruption Act 1988, the question of another accused committing an offence under Section 12 of abatement by aiding does not arise. An abatement being a complete offence in itself, its attempt is punishable under Section 511 of the Code. Thank you for watching. Please like, comment and share the video. Also subscribe to our channel. Keep coming back. Thank you.